In this video, we're going to be talking about the preliminary examination, or it's commonly known as the preliminary hearing in the context of a felony criminal defense case. Now, the preliminary hearing is what most people consider, other than their first bond appearance, their first appearance, the real first meaningful hearing in their case. This is where they're going to hear evidence against them. They're going to get an idea of kind of how their case is going out, aside from just what's on paper. Now, what the preliminary hearing is it's basically a mini trial. It's a time in which the state has to meet a low burden in front of a judge or a threshold of evidence to show a judge a couple of things. One, that a crime has been committed, and two, that the defendant is one that committed the crime. Now, they don't have to show a high burden of proof, like beyond a reasonable doubt, like they would at trial. They only have to show probable cause exists. So it's a low burden, and most people are bound over on preliminary examinations. Now, what bound over is, it's a term of art that lawyers use. It just allows the case to go forward. In other words, the judge says, I believe that probable cause exists, that a crime's been committed, and that the defendant committed the crime. Just a low burden of proof has been established, and I'm going to allow the case to continue. Now, just because a person is bound over after a preliminary hearing doesn't mean that they've lost their case, doesn't mean that they're going to jail, doesn't mean anything like that. It just means that the judge has allowed their case to go forward. Now, many people will say, since it's such a low burden of proof at the preliminary examination, why do I want to do it? Well, for your criminal defense lawyer, the preliminary examination is invaluable. Your criminal defense lawyer gets a chance to cross-examine the witnesses, gets a chance to view the witnesses. They have to show up to court, so your lawyer gets some insight on their willingness to cooperate with the police, or the state in this case. And the lawyer gets an insight to see how they perform on the witness stand. It can be a good time for your lawyer to ask them questions and flesh out the answers so that they understand the case better, and it can be used as a very good tool for discovery. For more information on the next step in the criminal defense process, or filing motions, please watch our next video